Hello, my name is Kyle Melling and I am one of the attorneys here at Lowe Scott Fisher. Today we're going to talk about why and when we need to retain expert witnesses and how they help your case. Whenever a potential case is referred into our office, we have to analyze a few key features to determine whether it is a case that we can handle and to adequately advise our potential client on how the case will go. One of the key features that we look at is which expert witnesses we believe we will need to prevail at a trial in the case. Expert witnesses are used by both plaintiffs and defendants to help explain complex topics to juries and judges. Their testimony can help give a jury a better understanding of the evidence and the facts at issue in a case. This includes what the evidence may imply and how to interpret it. These expert witnesses have to be qualified, and the issue of whether they are qualified is one that a judge makes. The judge will review the expert's credentials, their publications, their experience and education, and in some circumstances, will consider their reputation as to whether they have been deemed qualified to testify on certain topics in prior cases. The judges use this information to decide whether the expert is qualified to testify in your case. In our personal injury practice, which includes auto accidents, products liability cases, and medical malpractice cases, there are generally two categories of experts that we use. First, there are damages experts, and second, there are liability experts. Damages experts are the experts that link the accident or incident that gave rise to the case with the injury that the client suffered. As an example, in an automobile accident, we have to retain a doctor. Usually that doctor is the doctor that's been treating the client for their primary injuries. That doctor expert has to provide a report and testify that the accident itself proximately caused the injuries that are being claimed in the case. Another example of a damages expert would be an economist. Many times in our cases, our clients have lost significant wages, either due to time away from work or their inability to return to work. We use economic experts to explain to a jury the amount of lost income an accident caused a plaintiff. The second category of experts that we use in our personal injury cases are liability experts. These are experts that help a jury determine who is to blame for an accident. Again, using automobile accidents as an example, many times we will retain an accident reconstructionist. This is someone who is trained to review the scene of an accident, take measurements of things like skid marks and damages to vehicles, and determine how an accident occurred. This expert then is presented to a jury and they explain their findings. A big question that arises is when do we need to retain these experts and at what point during the litigation are they used? For our liability and damages experts, we usually retain them prior to filing suit or shortly after we file suit, but they usually do not present reports and testimony until after all the discovery in a case is completed. They then review all of the evidence that has been unearthed in discovery and present their findings first in the form of an expert report. Following the production of their expert report, they will present for a deposition and ultimately they will testify at trial. An exception to this arises in medical malpractice cases. This is because in Ohio, to file a medical malpractice claim, the law requires that a plaintiff present what's called an affidavit of merit. In short, an affidavit of merit is essentially a statement from a qualified medical expert that after they have reviewed the medical records and the claim, they believe the appropriate standard of care was breached, and that that breach caused the injury that the plaintiff is claiming. Accordingly, for our medical malpractice claims, we usually have a report and an affidavit prior to filing suit. This report can then be updated prior to that expert's deposition, depending on what evidence was uncovered in discovery. I hope this video helps to explain the how, why, and when we use expert witnesses in the course of your case. Should you have any questions or wish to speak with an attorney at Lowe Scott Fisher, please call one of the attorneys here at any time. Thank you so much.